your lesson. You've been in prison several times, and firearms have been the key on several of these, and you're still misusing. Now, I know you made messes in Louisiana, but now well, I say welcome to Texas, but don't come here and mess us up. And here you are, bringing bringing your mess into this state. Shame on you. CR 1839, Mr. Williams, you probably are intimately familiar. This isn't good. So I always look ahead to see how this ends, how the story ends, and it's not good. You are punished in America criminally in two phases: the circumstances of the crime and criminal history. Those are the two parts that make up the punishment. You are charged here in this indictment with the third-degree felony of unlawful possession of a firearm by a previous convicted felon. So we know you have a previous conviction, at least according to this indictment. Then paragraph 2 goes on to state that you were convicted out of Jefferson Parish, Louisiana in 2012 for use of a firearm, and it says CDS, I don't know what that means, or crime of violence. Then paragraph 3 of the indictment states,
right away, you can tell this hearing isn't going to be a routine bond discussion. The judge isn't just looking at the current charge, he's already digging into the defendant's history. And in criminal court, that's where things can get very serious. The question isn't just what happened today, it's also what has happened over the last decade. Let me ask you this. Should someone's past mistakes heavily influence how they're treated in a new case, or should every case stand on its own?
In November 7th of 2013, out of Jefferson Parish, you were convicted of illegal possession of heroin, cocaine, and a felon in possession of a weapon, which you're charged with now, which should never happen again. Paragraph 4 goes on to allege that after the conviction of firearm use or crime of violence in 2012 out of Jefferson Parish, Louisiana, became final, and after the conviction of illegal possession of heroin, cocaine, and convicted felon with a weapon in 2013 out of Jefferson Parish, after those convictions were final, it is alleged you committed the felony of introducing contraband into or upon the grounds of any state correctional institution, and you were finally convicted of that. They bring contraband into a prison, I guess. You were convicted of that out of Franklin Parish, Louisiana in 2018. And finally, the final paragraph of the indictment goes on to state that after the conviction in clause number 3244, which is, again, those firearm and possession convictions in 2012, and after the conviction of illegal possession of heroin, cocaine, and being a convicted felon with a weapon in 2013, all out of Jefferson Parish, Louisiana, became final. You committed the felony of introducing contraband and were convicted of that felony in 2018. I guess that's what I don't understand why that's in there. Nonetheless, that last paragraph seems confusing, but on balance, this means because of your rich criminal history, you are looking at a minimum.
This is the moment the courtroom atmosphere changes completely. The judge hears 25 years to life and immediately shifts focus from paperwork to public safety. Notice how quickly the bond discussion escalates. From the judge's perspective, he's looking at someone who has allegedly been warned by the justice system multiple times and is now facing another firearm-related accusation. Whether you agree or disagree, one thing is clear. The judge believes this isn't just another defendant. He sees a pattern.
Of 25 years in prison to life in prison. A minimum of 25 years in prison. Up to life in prison. Do you understand? What's his bond on this? This is egregious. And then right now, another illegal possession of a firearm. Not on my watch.
$100,000.
That is revoked. That's not sufficient under this. Under all of these convictions, and it's still firearms use, it's not fair and right. I'm increasing it to $200,000.
Your Honor, I would argue.
You can argue. Go ahead and make your statement.
He's been in court every single time. He's never missed court. He's always been here. That's one of the main reasons for bond is to make sure.
It's one of the main reasons.
That's why I said one of the main reasons. This is if you look at his prior history, it's
just look at.
Oh no, but it's nothing recent. It's cases that are old.
I'm sorry, he just got indicted. He just got indicted. That's recent. He just got indicted here on this case.
No, I'm saying his prior history.
He should never ever commit a crime, much less repeat it. And I'm sorry, that's just, and it's firearms usage.
Another firearm using a firearm.
He's illegal possession of firearms.
Wasn't used. It's found in the car when he was driving.
Yeah.
I'm not saying it's illegal, but it's not the same thing as brandishing a firearm or using a firearm. I just want to make sure.
Paragraph 2, conviction in 2012, illegal use of a firearm.
But like you said, 2012.
I'm not through. Hold on. In 2013, convicted felon in possession of a firearm.
Now we're seeing the central conflict of this hearing. The defense is arguing that past convictions are old and that the defendant has been showing up to court. The judge, however, keeps returning to one issue: firearms. This is a classic courtroom battle between rehabilitation and risk assessment. Has enough time passed to show change, or does the repetition of similar allegations suggest the danger is still there? That's the question driving every decision being made right now.
He just got indicted for it here. He was convicted. This is the third, 2 convictions so far, and then now a third charge of illegally using a firearm. Let's see. What else? But you were he was a habitual felon. Let's see. 2 convictions ago. He was a habitual felon 2 convictions prior. And after being a convicted felon, after being a habitual felon, he was convicted of 2 crimes and now a third one.
Your Honor, I don't know the rules in Louisiana. I'm not sure about their
habitual felons is. I'm just looking at the habitual felon rules here for Texas and why we treat it the way it is.
Right.
But the point is, he had been treated tantamount as an habitual felon here in Texas 2 convictions, felony convictions ago, and now he's charged with a firearm. Yes, this is most serious. This is one of the more serious cases I've dealt with recent. Shame on you. You can't learn your lesson. You've been in prison several times. And firearms have been the key on several of these, and you're still misusing. Now, I know you made messes in Louisiana, but now I say welcome to Texas, but don't come here and mess us up. And here you are, bringing your mess into this state. Shame on you.
Your Honor, if I were to request maybe some stricter bond conditions, but leaving he's working and
How do we keep him from possessing a firearm?
hopefully possesses a firearm in the meantime. That's
You mean again?
Yeah, I mean
This is his third charge. Third, he's been convicted twice of this. Now it's a third one.
obviously
There's nothing we can do. There's nothing we can really do to stop him from misusing firearms. He makes a mess wherever he goes, and now it's in Texas. Say welcome to Texas, but don't make messes. But note, whoever set the bond, I just articulated more than enough reason that his bond was.
Listen carefully to what's happening here. The defense is focusing on the amount of the bond, while the judge is focusing on the potential sentence. And legally, that's an important distinction. If someone is facing decades or even life in prison, judges often view them as having a stronger incentive to flee. The bigger the possible punishment, the bigger the concern about whether they'll return to court. Do you think a $100,000 bond was enough in this situation, or was the judge justified in raising it?
Insufficient.
And the other argument I make, Your Honor, his bond was set quite a while ago. He's been coming to court. This is not his first time appearance. We've made appearances.
This is this court.
Well, we've been in front of this IRS and reset
This court, and always. Show me a statute that says I can't do what's in the best interest of the safety of this community.
I'm not saying you can't do it, Your Honor. I'm just asking you not to.
He has a prolific liking toward illegal use of firearms. And that's irresponsible. It's dangerous. And now he's here. And he's in front of us after Louisiana finally put him into Texas. Now here we are. And now we're dealing with, he's an habitual. He's looking at 25 to life now.
Oh, another range.
Yeah, yes, 25. How much is that worth in a bond? You think $100,000 is too much for 25 to life? I don't think so.
Well, that's what it is right now.
Not when he was looking at habitual felon status, 2 convictions previously ago.
And I think you made my argument right there, Your Honor. If this was a $20,000 bond, I would agree $20,000 is sufficient, but $100,000 is sufficient for something like this. And that's what he's on right now.
The court finds otherwise.
I mean, he's on a very high level.
No, your representation, a vigorous representation is noted, which is good. But still.
Here's what really stands out. The judge isn't focused on just this arrest. He's looking at a history of firearm-related convictions and asking one question: has anything changed? Whether that's fair or unfair depends on your perspective. Supporters would say he's protecting the community. Critics might argue he's allowing past conduct to overshadow the presumption of innocence in the current case. Either way, this hearing has become about much more than a single charge.
It's hard for you to create facts that don't exist, and the facts speak loudly. He is irresponsible with firearms, and now he's in Texas after numerous convictions, felony convictions in Louisiana. Now he's bringing his mess into Texas, and we're going to deal with it. And each time it gets more severe. Well, that's what I'm articulating the grounds for my decision. And
here's what really stands out. The judge isn't focused on just this arrest. He's looking at a history of firearm-related convictions and asking one question: has anything changed?
And that's the court's decision.
We can get it on a quick docket relative to them, see if we can get it resolved.
You can put it in 2 weeks. Is that good?
Yes, please.
Okay, I'll review it in 2 weeks. See what y'all might be able to do.
Talk across your range.
But the one thing is, sir, you can't even get near a firearm. Sir, you got indicted.
And this final exchange perfectly captures the tension in the room. The defendant insists he hasn't been in trouble, while the judge points to the reality that he's currently facing a charge carrying a potential sentence of 25 years to life. It's almost as if the two men are speaking different languages, one focused on recent behavior, the other focused on legal consequences. As this hearing comes to a close, the bigger debate remains unresolved. Was the judge protecting the public, or was he effectively punishing someone for a lifetime of prior mistakes?
For possession of it. Come on. Again, and another with your convictions of firearm misuse. This is the problem.
Those were all ranked concurrent. That was one thing.
Yeah, concurrent. They were different crimes. I don't care how they do it over there in Louisiana. They can, but over here, each crime has its own criminal responsibility and punishment. And if they want to package it as a package deal, they can do that. But that's not the way we do things in Texas. You are held accountable for each crime. You don't get to say, well, I'll do 5 of them and I'll do it 5 for the price of 1. That's not the way it works. That's like a criminal thought. And that's not the way criminals should think, and that's why criminals get in problems. Okay.
I haven't been in any trouble.
Sir, you're in trouble now. For illegal possession of a firearm. You're looking at 25 to life. You don't think that's trouble?
Yes, yes.
All right. Well, deal with that responsibly. Who's a good lawyer? See if y'all can figure something out. Thank you.
The answer is no. Interview 1. This hearing ends with a higher bond. But the debate is far from over. Was the judge protecting the community, or was he punishing the defendant for his past? Let me know where you stand.